Hello, this is attorney Dan Marr from Hamblett Kerrigan in Nashua, New Hampshire. I've been practicing law here in New Hampshire for approximately 36 years and in the Commonwealth of Massachusetts for approximately 28 years. I've represented a lot of creditors, including financial institutions. I'm going to be talking today about what happens when somebody is trying to avoid paying their debt that's owed to you by transferring assets out or taking on obligations that are false. I've had quite a bit of experience in regards to this. I've represented during the bank foreclosures. Under FIREA, the federal statutes, I represented the holding companies that were helping the FDIC deal with these issues. And I've had also regular business-to-business situations upon which people are trying to avoid their debts. New Hampshire, outside of what's available for the federal law for banks called, or FDIC called FIREA, it's an acronym. I'm going to be talking about New Hampshire's Uniform Fraudulent Transfer Act. We have an act that is a uniform law from a variety of states that the New Hampshire legislature has adopted. It's called the Uniform Fraudulent Transfer Act. It has also been talked about being possibly used as the Uniform Avoidable Transfer Act, but it's never gained enough traction to change the name. I think they should change the name because while it's called the Uniform Fraudulent Transfer Act, there's subjective and objective fraud. There's situations upon which a debt is or a transfer is made that is avoidable to the creditor even though there was an actual intent. First and foremost, under the Act, if somebody owes you money and they transfer their house to their adult son and they still live there, I had that situation before, and they say, well, look, I don't own the asset, I transferred it over, I don't have any rights to it whatsoever, so you can't come after it for it. You can go after that house in regards to that. There's one thing to consider when you look at that statute is to the extent there's an exemption there, whether or not that transfer has happened. This happens a lot with husbands and wives where a husband and wife are on the debt and say there's maybe $200,000 worth of equity in the home, and the wife is in business and she has a debt and she transfers her interest in the property to her husband. Well, she had a $120,000 homestead exemption in regards to debts that are not taxes, property taxes, not a mortgage, not a voluntary lien. So that regular business debt that she has $120,000 interest in. If she actually transfers over to her husband, there's an argument to be made, and I've seen this argument effectively made, that it's not a transfer of an asset because she already had an exemption of $120,000. But in the example I gave you, transfer to the brother, the adult son, he wasn't living in the property, but now he's saying, look, I own this outright, and I'm maybe renting it to my dad or doing a generous deal with my dad. I've gone after those, and I've been able to cut through those very easily and get at the property itself. You can't do that. That's a fraudulent transfer. And that was with actual intent. It's called under statute, hinder, delay, or defraud the creditor. So that's very easy. Say there's a situation where the dad decides just to be generous to his son and lets his son buy the property for half the value of the property, and he is having financial troubles, but we're not able to prove that he's doing this as a fake transfer. It's really the son is holding it for dad, and that's the actual intent to hinder, delay, or defraud. But he's actually transferring it to his son because maybe he's thinking, well, I want somebody to have it, and my son can't afford it, so I'm taking some of that money and I'm using some of that money to pay some of my debts. But it's not for the full value. To the extent that it's not for the full value, that made him insolvent or more insolvent, and you as a creditor can go after the son for that difference in the price. And there's some rules in regards to that. If the son was buying it in good faith, he certainly gets the credit for what he paid. But in that situation, you can generally go after the difference in the value on that property. So that's something. I've had situations also, and I've talked about this in other vlogs, where an insider of a company goes and has the company pay his debt, his legitimate debt, before he pays the third-party creditors. And in that situation, there's a provision under the statute that even though it's a legitimate debt that he's paying, you can go after that. I've dealt with that, and I can address that. If you have any questions, give me a call in regards to that. Another situation is if you create a obligation that's a fake obligation. I had situations where people have created mortgages and they were fake, or they transferred the property and took a mortgage back and the whole transfer was a fake. In those situations, you can go after those under the Uniform Fraudulent Transfer Act, and I've done that both for financial institutions, businesses, and the like, going as a creditor, going after those assets and the transferees. So I'm attorney Dan Marr at Hamblett Kerrigan here in Nashua, MARR, and it's 603-883-5501. Our telephone number is 603-883-5501. You can also check out our website that has all my vlogs. You can just go to my bio and you can click on to the YouTube channel that has all these. I do weekly vlogs on a variety of topics, and the website is NashuaLaw, all one word, .com, NashuaLaw.com. I look forward to working with you if the opportunity arises. Thank you.